Hey folks, this is your accountant Mansoor Sohail. I operate out of Toronto, Ontario, and my specializations are taxes for Canada and USA. My presentation today is only for educational purposes. It does not constitute any legal advice or opinion. So please do not use any of its contents without seeking a professional advice. I will be talking about sales of business today and where sale and purchase of assets is involved. So sale of business can take place either by sale of assets or by sale of shares. We'll be talking about sale and purchase of assets. In this scenario, vendor has a choice to sell assets of his or her choice. If the price allocated to an asset is greater than its book value, the vendor's recapture of capital cost allowance becomes taxable income for vendor. If the price of an asset is greater than the cost of the asset, the difference between cost and price recovered is subject to capital gains tax. In an asset sale, vendor can be left with assets for which corporation has no use. After disposal of assets, shareholders and directors of the vendor corporation are left with the task of winding it up and preparing tax returns and corporate filings. Purchaser can pick and choose the assets he or she wants. Vendor has the choice to accept the purchaser's terms. Purchaser of assets assumes no debts or liabilities other than those specifically agreed to. The purchaser will start capital cost allowance calculations based on the purchase price of the asset. By picking and choosing among the assets offered for sale, it is possible that the purchaser will overlook assets that could be useful in business. It is possible that a purchaser may never be regarded by customers and suppliers as the legitimate successor to a business if the purchaser does not acquire the entire business by way of share sales. Asset sales are usually negotiated by the parties themselves or through a commercial broker or an agent who specializes in the purchase and sale of business. The agreement of sale and purchase will have following information. Parties. The legally correct names of the purchaser and vendor. Purchase price. The offer must indicate the purchase price and clearly set out the details of how and when the price is to be paid. Assets. The assets being purchased are listed in a schedule attached to the agreement of purchase and sale. List of items. It is important to provide a precise description when listing items such as office equipment, models, and serial numbers. Inventory. An asset purchaser who wants to continue operating the business will usually purchase its inventory. Inventory is usually counted on the day of closing of the evening before, and its value is added to the purchase price. If the vendor is a manufacturer, the term inventory also includes the raw material and work in process owned by it and used to manufacture its products. Intellectual property. If business names, patents, or trademarks are being purchased, they must be described in full. The vendor must arrange for the transfer of any patents or trademarks to the purchaser. Goodwill. Goodwill is the term for those intangible aspects of business such as its reputation, client base, and location that go into making it a recognized and successful concern. Goodwill is often assigned a dollar value and included in the agreement of purchase and sale. Real property. Any real property being purchased must be identified in the asset agreement of purchase and sale and must also be dealt with in a separate real estate agreement. Lease agreement. In case where the business premises are leased by the vendor, the agreement will specify that the vendor is to assign the lease to the purchaser on closing. The effect of the assignment is that purchaser assumes all the rights and responsibilities of the lease originally entered into between the landlord and the vendor. Most commercial leases require the landlord to approve an assignment. The purchaser needs to give the landlord sufficient information for a credit check. Allocation of purchase price. It is always best to include an allocation of purchase price as it relates to each asset or category of assets. Training. In many cases, the purchaser requires the vendor to provide training in the operation of business. The nature of this training should be clearly in the agreement should be specified clearly in the agreement, including details on how long the training is to last. Non-competition. A purchaser who is buying the assets of a successful business will not want the vendor to start a competing business after closing. A purchaser must ensure that the agreement contains a clause stating that the vendor or its shareholders and directors agree not to compete as owners, partners, employee, shareholder, consultant, or otherwise with the purchaser in a specific territory for a specific period of time. Employees. Asset sales agreements often state that the vendor is required to terminate the employment of all its employees in accordance with the notice and severance pay requirements of employment legislation and the common law, and is legally responsible for any failure in this regard. This enables the purchaser to hire whichever of the vendor's employees the purchaser wants. Confidentiality and non-disclosure. If the business is large or needs to safeguard valuable trade secrets, or if the transaction is going to take long time to complete, the purchaser may be asked to sign a document stating that confidential information acquired during the negotiations will not be disclosed to others unless acquired as part of the sale itself. The vendor, in return, may be asked to keep information about the business confidential after closing. PPSA search before closing. If a PPSA search discloses a registration against the vendor, the purchaser will want a discharge before closing. In case where the purchaser has agreed to assume the liability in question, the creditor will take steps to amend the PPSA registration to show the transfer to the purchaser of the asset that is security. Real property. When the purchaser is buying assets that include real property, the usual real property searches must be performed. These include a little search to check that the vendor holds good title and that there are no liens and so forth against the property. Searches to ensure that municipal tax and utility payments are up to date, and searches to ensure that there are no work orders against the property and that it complies with all zoning bylaws. Bulk Sale Act. The lawyer of purchaser conducts the bulk sale search to ensure that creditors were properly provided for in the prior transaction and will not follow the current vendor or purchaser for funds. No search is required if the vendor in the current transaction is first owner of the business. Corporate searches. When the vendor is a corporation, searches must be performed to ensure that it is valid and in existence. In other words, it has not been dissolved or wound up. Corporation Point in Time Report. This report provides a list of all directors and officers on file at the specific date. This report is particularly useful if one needs to know who the directors and officers were at a particular date. Corporation Profile Report. This report provides information based on the most recent Form 1 filed by the corporation under the Corporations Information Act. It also includes information from any articles filed by the corporation. Corporate Document List. This search identifies all documents filed with the company's branch by the corporation since June the 27th, 1992. Certificate of Status. This document provides information on the current status of the corporation. It indicates whether the corporation has been dissolved. Because the certificate is tied to a specific recent date, the corporate search reports need to be obtained to ensure that the vendor was continuously in existence during the time it owned assets. If it was not, it probably does not have title to the assets. Current business names registered by a corporation. The list of current business names registered by a corporation provides all the business names filed by the corporation within the past 5 years. This search report is obtained when a business name other than the registered name of the corporation itself is being purchased as an asset of the business. Bankruptcy. The purchaser must ensure that the vendor is not an undischarged bankrupt. If the vendor is an undischarged bankrupt, he or she cannot sell the assets because they will have been assigned to a trustee in bankruptcy. Other searches. Where assets are being purchased from a business concerned with trucking, shipping, aviation, or railway, other searches may be needed to ensure that no liens or encumbrances have been registered against the asset and that all the licenses for carrying on business with the assets are in good standing and transferable to the purchaser. Documents that are required on closing. Bill of sale. The purchase of bill of sale is to verify under oath that the transaction is legitimate and is undertaken in good faith for the value. The consideration noted in the bill of sale relates only to those items that attract retail sales tax. Other documents. For assets such as patents, motor vehicles, and real property, a bill of sale is insufficient to transfer ownership. Other documents such as deed of land are required from the vendor. Shareholders resolution. If a corporation is selling all or most of its assets, Section 184 of the OBCA requires approval by a shareholders' special resolution. Transfer of business name. The vendor's business name is part of the asset sale. Where the name has been registered under the Business Names Act, the vendor registers a cancellation of its right to use the name and the purchaser registers the name at its own expense. Assignment of lease. If the purchaser is taking over a commercial lease, he or she needs following documents on closing. The assignment of the lease from the vendor. This gives the purchaser the right to occupy the premises for remainder of the term as well as any rights of renewal that might be in the lease. The landlord's consent to the assignment. This is usually required by the lease. Failure to obtain it can avoid the lease and expose the purchaser of eviction. An acknowledgement from the landlord that the lease is in good standing, that rental payments are up to date, and that there is nothing to prevent the new tenant from exercising any renewal options in the lease. The acknowledgement also confirms the amounts payable under the lease and the details of any security deposit or payment towards the last month's rent. Income tax affidavit. Section 116 of the Income Tax Act requires the purchaser to withhold one-third of purchase price for payment to the government in the event that the vendor is a non-resident of Canada at the time of signing the agreement of purchase and sale, to sell the business, or at the time of completion of the transaction. Registrations that are required after closing. After closing, purchaser's lawyer must immediately attend to the following registrations. Where applicable, cancellation of the vendor's business name under the Business Names Act and registration of that name by the purchaser. If purchaser has acquired the name of vendor's corporation, the lawyer must ensure that the vendor has registered articles of amendment. An affidavit of the Bulk Sales Act, which is affixed to the Bulk Sales Act documents received from the vendor on closing and then registered with the Office of the Superior Court of Justice in the jurisdiction where the business is carried on. If real property was purchased, the deed and other applicable instruments must be registered on title. File the mandated elections from under the GST with Canada Customs and Revenue Agency. This permits the sale of substantially all of the vendor's assets without requiring payment of GST. References. All this presentation comes from the Fundamentals of Corporate Law and Procedures. I have used this book for this research, written by Mark Velma and Patricia McCann Smith. Publisher, Edmund Montgomery Publications Limited, Toronto,